ಓ ಇವ್ ಅಲ್ಲಿ ಮಾಡ್ಬೇಕಾ ಅಲ್ಲಿ ನಾನು ಮೀಟು ವಿಡಿಯೋ ಅಲ್ಲಿ
ಅಲ್ಲ ಸರ್ ವಾಯ್ಸ್ ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ ಹೋಟೆಲ್ ನಂಬರ್ 22 ಇಂದ
ಕೇಳಿಸ್ತಾ ಇದೆ. ಕೇಳಿಸ್ತಾ ಇದೆ.
Number 47, E. Muralidhar.
Yes.
The defendant's appeal, my lord.
There is a mention being made. 1 second, sir, please. When do you want it? No, take it. This serial number 50. The request of appellant call on 15th. Okay.
47.
Yes, 47. Here is sir.
Please, my lord, the suit for bare injunction filed by the respondent for restraining the appellant from forming a road over her property, my lord. She has given reference to the sketch. Lordship may kindly take up exhibit P6 that at page 41 is the sketch to understand the facts, my lord. Page 41, my lord, of the paper book. He claims to be the owner of that entire property, my lord, A, B, C, D, E, F, G, measuring 100 feet by 36 feet. She's stated that one portion of the property, my lord, that is C, D, E, F, is encroached by another person, by one Munimotappa, and another suit is pending against that portion. The case is that corporation is forming the road in the middle of our property, that is, my lord, mentioned by letters B, C, E, F, G. B, C, F, G. B, C, F, G. In the just before Munimota.
Got it.
Yes. She claims to be that corporation is forming the road in that portion, my lord, and she is the owner of that entire property. Corporation has filed a statement, my lord, denying her title over the property, and that there was earlier a Kacha road was there, and BBMP has asphalted it and made a Pakka road now.
Now it comes within BBMP limits, right?
Yes, it came within the BBMP limits in 1996, my lord.
Okay, when they handed over the.
No, this was a revenue layout, my lord, and there was no layout plan, nothing like that, my lord, to show that existence of roads and sites.
Was this a government property or whose property?
No, it is a private property. That is what she claims. She has
No,
purchased
she may
it from.
claim 101 things. What, according to you, is the nature?
According to us, my lord, when it came to our jurisdiction, my lord, the road was there, and we have developing those area.
Revenue records ಏನು ಹೇಳುತ್ತೆ ಅದ್ರ ಬಗ್ಗೆ?
That has not been verified, my lord, by the.
No, that has to be done. No.
Yes, but plaintiff has also not produced any document, my lord, to show that it was a government land or a private land. Only she produces her sale deed executed by a previous owner in the year 1979. In the sale deed also, my lord, on southern side of the property, the road is shown, my lord. Subsequently, in the year 1994, after lapse of 14 years, they execute a rectification deed to show that there was no road. That is, Exhibit P2 is the 79 sale deed, or sale deed, and 94 Exhibit P5 is the rectification deed. The trial court, my lord, after discussing, my lord, after considering the evidence of the both sides, my lord, has come to the conclusion that there was interference by the BBMP in forming the road without acquisition. Illegally, they are trying to form the road. That is what the country. Lordship, the discussion is found at page number 54, my lord, of the paper book. Reasoning of the trial court. I read that, my lord, the plaintiff, the commencement of the paragraph, my lord, the plaintiff has placed sufficient and substantial material in proof of her lawful possession over the suit property on the date of the suit. It is stated by PW1 before the court that the defendants and their men prior to the suit by coming near the suit property were found doing the work of forming the road, which was resisted by her, and therefore she has filed the suit before the court preventing the said act as the work of road was in progress. It is true that she has admitted in the evidence that she did not take any photographs to show the road work in progress said to have been taken up by the defendant and produced before the court. But that alone cannot be the reason to non-suit the plaintiff in view of the contentions raised by the defendants in their written statement and put forth by way of suggestion during the course of cross-examination of PW1, wherein it is specifically contended by the defendants that there was an existing Kacha road which has been made Pakka by the defendants for the use of the public. The defendants, in proof of their contentions that there was an existing road in the suit property which was in use by the public as a Kacha road and which they are said to have made it Pakka, have not placed any iota of evidence before the court to substantiate the said contentions. No village map is placed before the court to show that the Kacha road was passing through the suit property and was being made was being used by the public at large, and which has been improved and formed as Pakka by the defendants after taking over the said area, and it's falling within the limits of corporation in the year 1996. Therefore, in the absence of any supporting documentary evidence and ocular evidence, mere contentions raised in the written statement by the defendants that there was already existing road from many years and no inclusion of the said area in the limits of BMP during the year 1996. The defendants have only maintained it cannot be accepted in the absence of any documentary evidence. The contention raised in para 3 of the written statement reveals that the defendants specifically contended that there was already existing road from many years in the said area, but the suggestions put to the witness during the course of cross-examination reveals that there was existing Kacha road, which has been made as Pakka road by the corporation. Therefore, the very suggestion put to the witness during the course of cross-examination is contrary to the contentions raised in the written statement at para 3, which shows the inconsistency in the defense, and as such, the evidence of any documentary or oral evidence in support of any of the said contentions, it cannot be said that there was any road either Kacha or Pakka in the suit properties since many years as contended. On the contrary, the documents produced before the court by the plaintiff clearly established that it is a house list and a site having the measurement of 36 feet by east-west and 100 feet north-south, including the portions said to be in unauthorized occupation of one Munimotapa, and there was no road as such passing through the said property. Therefore, the very evidence of plaintiff and the witness examined as PW do before the court are sufficient to believe that the plaintiff was in lawful possession of the suit property on the date of the suit, excluding the portion in unauthorized occupation of the legal representatives of the Munimotapa, which includes the disputed portion ECFG, as described in the rough sketch at Exhibit P6 annexed to the plaint, over which the defendants had attempted to form a road without taking any recourse under law, which is...
Yes, sir. What is wrong in the reasoning of the trial?
Please, my lord, the suit itself is not maintainable, my lord, since the title is disputed, and BBMP, by the time she filed the suit, BBMP had already formed the road, my lord. In fact, in the cross-examination, my lord, she admits that the road was, in one breath, she admits that there was a road was formed, and in another breath, yes, they are attempting to form the road. Page 18 of, may kindly be seen, of paper book. Further, she says that corporation has also registered Kata in her name, but she doesn't produce any document, my lord. Page 18, my lord, from first line itself. Witness volunteers that Kata of the suit property was in her name with the Panchayat records then and now with the corporation also. I have not produced the document to show that Kata of the suit property in corporation records now stands in my name. It is not true to say that Kata of the suit property is not effective.
Sir, what have you produced to show that there was a road?
That, my lord, it was a revenue layout, my lord. We do not have any records to show that, my lord.
Village map iralva.
Village map road torsirodilla. This is a revenue layout. It was formed by a private party over his land. It will not be shown in the village map also.
See, if it's a revenue layout. Now, that portion of the property belongs to whom?
That, according, we do not know originally to whom it belongs, my lord. There was a road when it was handed over to the BBMP. We asphalted it. And
there might have been a road. It may be a cart road. Okay, it may be a cart road to go to the adjoining land.
Maybe even
That's
then, if cart road is there, my lord, then it will be shown in the village map. But this is a private layout formed on a private land, my lord. And this burden is on the plaintiff. Yes.
Yes, she has produced the sale deed. You have not seriously cross-examined her.
It has been, and we are not also led any evidence in the matter. Defendant has not entered the witness box.
Then what to do?
At least she should have sought for declaration or mandatory
Why
injunction.
she has to seek for declaration when she has a valid?
Because, my lord, when the suit was filed, road was already formed, my lord. That she has admitted.
Okay.
At the
In the
bottom
cross
of the-
examination, she admits there was a kacha road, and thereafter a pakka road has been formed. Take her to the take me to the cross examination.
Page 18, my lord, at the bottom of the about 7 lines, my lord. I had found the workers doing the work forming the road. Witness once stated that the road was formed and again stated that the work was in progress. It was on 12/6/1990. It is not true to say that the road was formed and again stated that the work was in progress. In one breath, she says that the road was already formed.
No, that's okay. See, she says that I visited the suit property. I found the workers doing the work of forming the road. Witness once stated that the road was formed, again stated the work was in progress.
Yes.
So what?
Why should she say that, my lord? That road was already formed.
Even if the road was there, an illegal road was there, how does it matter?
No, suit is not, she was not in possession as on the date of filing the suit.
It's a plain land, sir. It's a plain land.
In one portion, she has constructed her house. In another portion, another person is in the occupation.
See, she says the distance between the suit property and my residence at Kodati.
She is residing in another village, my lord.
Is about 16 to 17 kilometers.
According to her, my lord, the building constructed on one portion of the site is let out to tenants. That is what she has stated. She is not in possession of that property. She has let it out to tenants. She is residing in another village that is about 16 to 17 kilometers away from this property. But on the date of filing the suit, she is not in possession of that property. We have already formed a road on that. And then another portion of the property is occupied by another person, and another suit was pending as on that date. That is what she says.
So you have to produce necessarily some document to show that there's a road. Otherwise, how can it become your problem?
When the area was handed over to us, there was a Kacha road. It was a revenue layout.
You order the documents that you get when an area is handed over to you.
That, my lord, only boundaries of the area handed over to the corporation will be shown, not the layout, my lord. Because this is a revenue layout. If it has been formed legally, my lord, then there would have been approved layout plan or some such thing.
I'll tell you what. If it is a revenue layout, what happens? There is no surrendering of. Listen for a moment. There is no surrendering of common amenities to the authority.
Only area will be handed over to us for maintenance. Earlier village panchayat
of it is illegal, sir.
Earlier village panchayat was.
Revenue layout itself is illegal on the face of it.
Yes, revenue layout is illegal. Yes.
Revenue layout is illegal.
Yes.
What happens? See, first it's an agricultural land. When it's an agricultural land, the question of road does not arise. Number two, land is converted for
non-agricultural. Converted. It is not converted.
It is not converted. Then
sites are formed on the agricultural land. That is why it is called as a revenue layout.
So, according to you, it's an agricultural land.
Earlier, my lord, when it was handed over to her, there was a layout. But,
all right. Yes. See, it's an agricultural land, not converted in the manner known to law. Illegal sites were formed. Sites were formed illegally. And portions of them were sold to different persons.
Yes.
Okay, portions of them were sold.
Yes.
Now, whether revenue land or a converted land, A portion of the land can always be sold.
Yes.
Correct.
Yes.
Understand this much. Understand look at from the legal point of view.
Please.
A revenue land or a converted land. A portion of the property can always be sold. There is no bar on that. It may not be an approved layout,
Yes.
but a portion of the land can always be sold. By virtue of which she becomes the owner of the land sold to her.
No, they have mentioned on site number, kata number of the site.
Okay, fine.
Yes. Yes.
He becomes the owner of the land
Yes.
sold to her.
Please.
Right?
Yes.
She has to produce the necessary sale deed in that regard. She has produced.
Yes.
Now, unless there is a surrender of the roads made there and
There can't be surrender, my lord. The revenue layout, the person who made the revenue layout would have formed some road, my lord, to give access to the sites formed by him. It is unauthorized layout.
who has to agitate it? Who has to agitate it? The neighbors have to agitate it.
Yes, but the area
You are
when
not
the
been
area
able to prove. You are not been able to prove the existence of a revenue road itself.
that, my lord, that is
Supposing
what,
she buys a portion of the land. Supposing she buys a portion of the land, and a road is formed on that. That's illegal. See, she gets a right over the portion of a land.
yes.
Okay, now if the road is formed on that property, that becomes an illegality. Mere fact
Yes.
that the road was there, a kacha road was there,
Please.
and you made it into a pakka road, you don't get that right.
Yes,
If
my
that
lord,
kacha
but
road was on her property.
yes, but when by the time she filed the suit, my lord, we had already completed the works. She should
So
have
what?
sought for she should have sought for possession of that property.
What is the suit for? Bare injunction. Huh?
Bare injunction. Page 5 of the paper book, my lord.
Okay, where is the evidence to show that in a cross examination? Let us go through our cross examination.
At page 18, my lord.
1 second. Is the original code? Original cross examination. This road is
The
which part of the property council?
southern side. That is what our sale deed also shows that, my lord, on the southern side there is a road. That is Exhibit P2 is our sale deed, executed in the year 1979.
So when did you form the road?
Immediately after the area was included within our jurisdiction.
No, which year? Which year?
It was handed over in the year 1996. Subsequently, it has been, but the exact date is not stated. And she has filed the suit in the year 1998.
Now, rectification date, when did it happen?
That was 1994. That is Exhibit P5, after lapse of 14 years.
That's okay.
Exhibit P5, my lord, at page 37 of the book.
What documents you have produced, counsel?
Yes, that is right, my lord. That was
What do you want to do now?
so, my lord. I leave it at that, my lord. Or lordship may kindly pass this judgment, my lord. We can't improve the case at all, my lord. Our witness has not entered into witness box, and whatever was material was there was placed before the trial court. On verification of the on internet, my lord, I find that the suit filed by her against that Munimotappa is also dismissed by the civil court. That was in the year 2003 itself.
Yes, there was a technical glitch. I couldn't hear you.
Please, my lord, the other suit filed by her again is that encroacher, my lord, Munimotappa, is also dismissed by the civil court in the year 2003 itself. I verified it on
What
internet.
can be done, sir? We have to go as per.
Please, yes, my lord, they have to. But burden is on the plaintiff, my lord. That is what
Putting the sale deed. No.
She has produced
And
it.
you are not being
But,
able to get anything much from her.
but
mouth.
a portion of the property is also encroached by another person, and that suit is also dismissed.
That doesn't come to your rescue. That might have been dismissed for any number
But
of
that
reasons.
shows, my lord, that she is not in possession of the extent shown in the sale deed. The first sale deed, my lord, that
That's
is
okay, but
79.
that doesn't mean that she is not in possession of the property claimed by you as a road. What is there right now? What is there right now? What is there right now?
Right, my lord. They have to seek for declaration and seek possession of the
No, no,
same.
no.
After
What is
2
there
weeks.
in the property right now?
The road belongs to the BBMP, my lord.
Sir,
No, please.
are you able to hear? Are you able to hear the court?
Yes, yes, my lord. I can hear, my lord.
ಇವಾಗ ಏನಿದೆ ಅಲ್ಲಿ ವಾಸ್ತವಿಕ ಸ್ಥಿತಿ ಏನಿದೆ?
ಈಗ ರೋಡ್ ಇದೆ ಅಲ್ಲಿ ಅಂತ ಹೇಳೋದು.
Okay, now listen. Go
Please.
to the map, but
Yes.
whatever map that you showed.
Yes, exhibit P6, my lord.
Exhibit P6. Now, where does that road lead to?
There is another property on the other side, my lord, of the.
It is his. He should be filing the suit. Huh?
Yes.
Okay, see, this road also does not lead to another road. It's a dead end.
This is a rough sketch, my lord, but it has not been disputed by the BBMP also. Yes.
Yes. Now, if you look at this map,
Yes.
what does
Yes,
it
I
show?
noticed it, my lord. It doesn't lead
It shows
to.
road on the western side.
Yes, that is the main road.
Okay.
Yes.
Yeah. And the alleged road on the southern side
Yes.
does not lead to another road.
It doesn't lead to another, but it leads to another property.
That property may have access elsewhere.
That, my lord, that is the. Yes, I noticed that, my lord. And,
Yes, then.
yes.
So the entire thing looks strange. Okay, now exhibit P2 ಎಲ್ಲದ?
P2 is the page. Page 26, my lord. It is shown as P1, but it is actually P2.
Exhibit P3.
Is the exhibit P3 another?
P3 is the plan issued by the village panchayat to the plaintiff, my lord, for construction of a building.
Okay, there is no road over here on the western side.
Yes,
ದಕ್ಷಿಣಕ್ಕೆ ಕುಂದಹಳ್ಳಿ ಪಾಪಣ್ಣನವರ ಹಿತ್ಲು.
please.
This becomes an authentic document, sir. Have you disputed P3?
No, it has not been disputed.
See, exhibit P1 is the P2 is the sale deed by which he purchased the property.
Yes,
Okay, then exhibit P5 is the rectification deed.
please.
Now the rectification happens prior to you getting a right over that whatever that area.
Yes,
coming
yes,
into
my
the-
lord. Yes, that's
Okay.
right.
Huh?
Yes, yes,
And then this exhibit P3 is a revenue record.
yes, my lord.
It does not show any road
The southern side. Yes, it tallies with the rectification
It
deed.
tallies with the rectification deed.
Yes,
Now you do not dispute
this
this document
plan,
at
my
all.
lord.
Have you document? Have you cross-examined anybody on this issue?
No, my lord. No.
No cross-examination
No cross-examination on that point.
on that document.
Yes,
Then what is P6? Please? Have
Please,
you
my lord.
cross-examined on P6?
P6 is no cross-examination has been done on those
On P6.
documents, my lord.
Yes. Then what remains? Have you produced any document to show
No,
that there
that
is a
is
road
what-
apart from the plain averments made in your
No, on
reconstruction?
the side of the corporation, we are, it has
And you are
not
not letting
produced.
any evidence also.
Yes, man, no, not even oral evidence also.
What to do, sir?
My lord, I leave it at that, my lord. That is all.
Here at least you could have produced some documents, asked for a remand. That also you have
Yes,
not
but
done.
they do not have any document to show that, my lord.
Right,
There
but
was
you-
already an airport.
Can't help you, sir. Yes. The judgment decree passed invoice number so and so by so and so, this is so and so. The instant appeal is filed by the plaintiff therein. For the sake of convenience, parties are referred to as per the status before the trial court. Instant appeal is filed by
Defendants, my lord.
defendants therein. Defendants. For the sake of convenience, parties are referred to as per the status before the trial court. The plaintiff claiming to be the owner of the property bearing old Gramtana site number 29, new number 84, as per house list number 96, measuring 100 feet into 36 feet, situated at Jakasandra village, Begur Hubli, Bengaluru South Taluk, filed OS number so and so. Is the defendant with the following relief. ಅದು prayer extraction, plain teller prayer for the following with the following relief. For the sake of convenience, the property in dispute. For the sake of convenience, the property in dispute is hereinafter referred to as scheduled property, and the description of the property is as mentioned below. Schedule. Full stop. Next para. The defendants have filed the written statement, denied the claim, and have denied the case of the plaintiff and sought for dismissal of the suit. Next para. The contention of the plaintiff is that she is the owner of the suit scheduled property and a road is sought to be formed by BBMP on her property illegally by the defendants, by the defendants, then brackets BBMP.
Yes, now BBMP. Then it was a corporation.
Illegally on a portion of her property. Full stop. The case of the defendant is that there was an already pre-existing road when the area was handed over to BBMP and they have only the governments made in the plaint and return statements. The trial court framed the following issues. An issue, sir. Next para. To prove our case, the plaintiff got herself examined as PW1 and also examined one case University as PW2 and got marked exhibit P12, P6. The defendant have not let in any evidence. Next para. The trial court, based on the pleadings and the evidence let in, has passed the following, has allowed, has decreed the suit of the plaintiff and has passed the following order. Order expect. Agreed by the same, the defendants therein have preferred this subject. It is the contention of the defendant that there was already a pre-existing road on a portion of the suitable property, pre-existing Kacha road on the portion of the suitable property, when however it is seen the defendants are not let in any evidence in support of their contention, nor have they produced any document to prove the same. Full stop. It is continued by the learned advocate for appellant / defendants that the plaintiff has to prove her case on her own strength and cannot depend upon the weaknesses of the defendants. And in the instant case, she has not been able to establish her title over the suitable property. And hence, the trial court ought to have dismissed this. And further, that the suit is one for bare injunction and no declaratory reliefs have been paid for, and the trial court ought to have dismissed the suit. Further, attention of the court is drawn by the defendants to the cross-examination of PW1, which reads as under. Then badabidi. Don't. Next para. The advocate, though the plaintiff is served, does remain. Next para. The plaintiff, to show that she is the owner of the suitable property, has produced copy of the sale deed dated 17/1/1979 and the rectification deed dated 19/5/1994. Full stop. It is noticed that the sale deed dated 17/1/1979, which is produced as Exhibit P2, mentions that there is a road on the southern portion of the plaintiff's property. Southern portion of the suit schedule property. Whereas the same has been rectified by the rectification deed dated 19/5/1994, which is produced as Exhibit P5, and southern and road is shown only on the west side of the property, and on the southern side of the property, no road is shown. Full stop. It is contended by the defendants. Uh, admittedly, the defendants the area in question where the scheduled property is situated fell into the jurisdiction of the defendants only in the year 1996.
Please.
In the year 1996. Full stop. And by then, the rectification deed at Exhibit P5 was already executed. Okay. The plaintiff has also produced a building plan approved by the panchayat. Village panchayat na idu.
ಹೌದು ಜಕ್ಕಸಂದ್ರ ವಿಲೇಜ್.
The village panchayat in respect of the suitable property which shows the boundaries as per the rectification deed at exhibit P5, and there is no road on the southern side of the suitable property. The defendants have not cross-examined the plaintiff witnesses in respect of exhibit P3, and they do not dispute the same. Correct, huh?
Please.
And they do not dispute the same. Full stop. Next para. The plaintiff, to prove her ownership over the suitable property, has produced the sale deed and the rectification deed, which also shows the boundaries. And there is no road on the southern side of the suitable property. Further, exhibit P3, which is the approved layout plan by the Gram Panchayat, is in consonance with, is in conformity with the rule of the property as per the rectification deed, and there is no road on the southern side. And these facts have not been and the plaintiff has been able to establish the same by production of the said documents. The defendants have not produced any iota of evidence to disprove the claim of the plaintiff. The trial court has passed the impugned judgment and decree. I do not find any error in the well-reasoned order of the trial court, and the appeal is hereby dismissed. Yes.
Much okay.
Ready? Are you ready to go on with the matter? You are ready to go on with the matter.
BM Siddhappa, BM Santosh.
Yan facts ili ಏನದು? What are the facts? Paper book ಕೊಡು. Genealogical tree ಕೊಟ್ಟಿದ್ದೀರಾ? ಎಲ್ರಿ? Hmm.
Shivkumar is the only son. Rest of them are daughters. Patel Mayappa have entered into a partition between Shivkumar and Patel Mayappa in the year 1987 itself. Patel Mayappa was right.
Now Patel Mariappa enters into a partition with Shivkumar in the year
1987.
okay.
There was ancestral property, so Patel Mayappa entered into a partition with Shivkumar in 1987. 6 acres for him. He gave a share of 6 acres. So 6 acres is given to all the others. But as a Christian, 6 acres is given. And we get
Listen, 1987 partition agata. Yenadu registered partition registered partition alli 6 acres Shivkumar. Okay. Then
daughters married was conducted, and only one daughter was unmarried. First time this Patel Mayappa. Patel Mayappa died in the year 1992. And his wife, his wife, has also died in 1997. So Patel Mayappa has not passed on any of the documents.
this is ancestral property or co-personary property? Co-personary property.
So thereafter, only sister Apparently are not married. Rest of them were not married, and they are living with the they are made as hearing parties as permanent. 1, 2, 1, 2, and 3. Thereafter, in the year 1992, the matter was with the entire property of his wife and unmarried daughter. As daughter got married, they stay on the house and get along with her. Suma was along with my grandmother. Suma was managing it. In the inheritance, that property was in the first thing. There was no partition with respect to the share of the property. All the properties.
Partition deed ಏನು ಹೇಳುತ್ತೆ 1987 partition deed ತೋರಿಸಿ 1987 partition deed ತೋರಿಸಿ. ಎಲ್ಲಿದೆ ಅದು ಎಕ್ಸಿಬಿಟ್ ಎಲ್ಲಿದೆ ಅದು? See, council, I'll tell you what. 1987, there's a partition. Let us presume for a moment. The partition says, ಶಿವಕುಮಾರನಿಗೆ ಈ ಆಸ್ತಿ ಮೇಲೆ ಹಕ್ಕಿರೋದಿಲ್ಲ ಅಂತ. ಹಂಚಿರೋದು ಸರಿ. ಈ ಪಟೇಲ್ ಮರಿಯಪ್ಪನಿಗೆ ಬರುತ್ತಲ್ಲ ಆಸ್ತಿ, ಅದ್ರ ಮೇಲೆ ಶಿವಕುಮಾರನಿಗೆ ಹಕ್ಕಿಲ್ಲ ಅಂತ ಏನಾದ್ರು ಕ್ಲಾಸ್ ಇದೆಯಾ ಅದರಲ್ಲಿ? ಹಕ್ಕಿಲ್ಲ ಅಂತ ಏನಿಲ್ಲ. So what happens? You show me that document first. Then see, they have also not produced. See, 6 ಎಕರೆ ಚಿಲ್ಲರೆ ಕೊಡ್ತಾರಲ್ಲ, 6 ಎಕರೆ ಚಿಲ್ಲರೆ, it becomes the exclusive property of Shivkumar. ಗೊತ್ತಾಯ್ತಾ? See, as on that day, you people had no right. Because the co-personers were only father and son. So registered partition. The property goes to Shivkumar. See, what needs to be looked into is what is the effect of that registered partition on the other properties. Listen, understand, it's a very tricky question. You'll have to understand it properly. See, what happens, 6 ಎಕರೆ ಶಿವಕುಮಾರ್ ಹೊಟ್ಟೋಯ್ತು. Now you have to necessarily analyze that partition deed. See, that partition deed might have the effect of the remaining properties being considered as the properties falling to the share of Patel Mariappa. Do they lose the nature of co-personary property is the thing that needs to be answered. Right, you know, if it loses the nature of co-personary property, then it gets considered as self-acquired property of Patel Mariappa, and it devolves equally amongst all his children and wife, including the son, upon his demise. If it continues to be in the nature of co-personary property, 1992 he died. 1992 he died. Co-personary property. Okay, son becomes the exclusive owner. There was no Karnataka amendment also by then. There was no Karnataka amendment also. Vinit Sharma has been interpreted by this court also. The judgments there. You have to analyze that partition deed, counsel.
I have only agreed with this one, but as other has raised before amendment of 2005, what would be the share of the father? Share of the father has come to the wife.
No. Share of the father devolves equally on wife and children.
Yes, equally on wife and children. Equally wife and children, I am entitled to 1/6. Now the 12 court has covered degree 1/12 share.
Why?
Because father has died much prior to 99.
It has gone for notional partition. Huh?
Notional partition.
See, that is the reason. See, notional partition is given because we have not analyzed that partition deed. That is the most important document. There is no error in the trial court order. See what happens. 1992 he dies. 1956 enactment itto. 1956 law itto. Karnataka amendment irlilla. So 56 law prakara ಏನಾಗ್ತಿತ್ತು? 56 act prakara co-personary property. On the death of the father, there is a notional partition. Okay, notional partition between father and son. So 50%. ಆರು ಜನ ಮಕ್ಕಳು ಹೆಂಡತಿ 7. ಗೊತ್ತಾಯ್ತಾ? So you are entitled to 1/7 share of 50%.
Now wife has also died.
That also you get 1/7 share of 1/6 share. So ultimately you get 1/6 share of the 50%. That has been awarded by the trial court. For you to dispute it, you will have to necessarily analyze the partition deed.
Partition deed, it is mentioned as in list, it is mentioned as it is mentioned as DW1, it is produced as DW1.
DW ಅಂದ್ರೆ ಡಿಫೆಂಡೆಂಟ್ ವಿಟ್ನೆಸ್ ಆಗುತ್ತೆ ರೀ. ಎಕ್ಸಿಬಿಟ್ ಟೈಪ್ ಕಮ್ಮಿ ಹಾಕಿದಾರ? ಇಲ್ಲ ಅಲ್ಲ, ಇದನ್ನ ಒಂದು ನಿಮಿಷ What is it? 159 page number exhibit D2 ಆಗುತ್ತಲ್ಲ. ಕ್ರಯದಾತ ಭೋಗ್ಯ ವಗೈರೆ ಪರವಾರ ಮಾಡಲು ಅವರವರೇ ಸಂಪೂರ್ಣ ಹಕ್ಕುದಾರರಾಗಿರುತ್ತಾರೆ. ಇನ್ನು ಮುಂದೆ ನಮ್ಮಗಳಿಗೆ ದೇಹ ಸಂಬಂಧ ವಿನಃ ಅರ್ಥ ಸಂಬಂಧವೇನೂ ಇರುವುದಿಲ್ಲ. Okay, so your contention is he lost all rights on remaining portion of the property, co-personal rights. So the remaining portion of the property has to be divided into 1/5, 1/5, 1/6. 1/6 has to be given, but his 6 acres has to be excluded.
I also notice that as of now I am accepting that he is the owner.
Just see, you should harp upon the partition deed. ಅರ್ಥ ಆಯ್ತಾ ನಾನು ಹೇಳ್ತಿರೋದು ನಿಮ್ಗೆ? If the party ಎಲ್ಲೂ ಪಾಯಿಂಟ್ ಮಾಡಿಲ್ಲ, the document you ought to have produced and you should have harped on it. See, if that partition deed did not terminate his rights as a co-parsoner on the remaining portion of the property, then in that event, he would have continued as a co-parsoner for the remaining portion of the property. In that event, the order of the trial court is perfectly valid. If we interpret the partition deed as terminating his rights on the co-personal property, and the co-personal property which fell into the share of other became his exclusive property, then in that event, Vinit Sharmanu Bekagilla, as a self-acquired property, you people are entitled. Yes, Bunny. Third in part, the advocate for the appellant present, advocate for respondent absent.
Appearing for the respondent.
ಏನ್ ಸರ್ ಇದು ಇಷ್ಟೊತ್ತು ಕೇಳಿ ನಿಮ್ಮನ್ನ ಕೂಗ್ಬಿಟ್ಟು ನೋ ರೆಸ್ಪಾನ್ಸ್ ಫ್ರಮ್ ಯುವರ್ ಸೈಡ್. ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೇಳಿ, ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋಣ.
ಅದು ಬೇರೆ ಬ್ಯಾಟರ್ನಾಗ ಎಂಗೇಜ್ ಆಗಿದ್ದ ಅದಕ್ಕೆ ನಮ್ಮ ಜೂನಿಯರ್ ಇರುತ್ತೆ ನೋಡ್ಕೊಳಕ್ಕೆ.
Nobody appeared. ಹೇಳಿ ಸರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. See, the arguments of the appellant has been, we go to the genealogical tree. Page number 12 of the paper book. That is not in dispute, right?
My request, madam, I did not gone through this.
When do you want, sir? He has finished his argument. I have heard him. I have to just hear you. When do you want? Take a date, finish it.
Please,
2 days, 3 days, not more than that.
3 days time. 3 days time.
Friday?
Above.
Okay. Heard in part, advocate for appellant and respondent present. You appear for whom, sir?
I am appearing for the LRs of the defendant number 3.
Hmm?
R3, R4, and
Tell somebody, advocate for appellant and respondent number 3 and 4 are present.
4 and 5
ಅದು ತೋರಿಸ್ತಿಲ್ಲ ಕಾಸ್ಟ್ ರೈಟ್. 3 and 4 are present. ಆಯ್ತು 3, 4 and 5. Yes, 3, 4 and 5 are present. Heard the advocate for appellant to hear respondents call on. Friday date ಕೊಡಿ. See, short point ಹೇಳ್ಬಿಡ್ತೀನಿ ನಿಮ್ಗೆ our arguments ಏನು ಅಂತ, because you are not there. See, ಒಂದು he harps on the genealogical tree. Okay, there are ಇದು he admits it's a joint family property, it's a co-personal property initially. Okay, the property belongs to the family of Patel Mariappa. During his lifetime, there is partition between him and his son, that is Shivkumar. Defendant number 3.
Please.
So in 1992, there were only 2, when the partition took place, there were only 2 co-personals. Neither Karnataka amendment had come into effect, nor the present amendments by the central government had come into effect. So there were only 2 co-personals, that is father and son. Only both the 2 had rights over the property. But what happens? There is a registered partition produced as Exhibit D1. Now, according to that, after the partition, certain lands are given to D3. That becomes his private property. Certain lands are given to the father, which becomes his exclusive property. The son, by reading of that document, has lost all his rights over the property, all his co-personal rights over the property which fell into the share of the father. Okay, then the father died, then the mother died. The property by virtue of the partition deed had lost the co-personal nature, joint family property. Having considered it as self-acquired property of the father, it has to devolve equally on all the children. So the appellant is entitled to 1/6 share in the suit schedule property. This is the contention. Get ready and come.
That is when the father died intestate.
Yeah, father died intestate, but see what had happened. See, father dies intestate. So 1956 enactment comes into picture at that particular point of time. 1992 he dies.
Even otherwise, Hindu Succession Act, Section 8 into the picture.
Exactly. See what happens. There is no question of co-personally.
Then all the children of that propositors will entitle for equal share.
Will be entitled for equal share. ಈಗ ನಿಮ್ಮ 6 acres ಏನು ನಿಮಗೆ ಮುಂಚೆ ಬಂದಿರುತ್ತೆ ಅದರಲ್ಲಿ ಅವ್ರಿಗೆ ಏನು ಹಕ್ಕು ಬರೋದಿಲ್ಲ. ಈ ಮುನಿ ವೆಂಕಟಪ್ಪ ಫಾದರ್ದು ಪ್ರಾಪರ್ಟಿ ಏನಿರ್ತದೆ ಅದರಲ್ಲಿ ಎವ್ರಿಬಡಿ ಗೆಟ್ಸ್ 1/6 ಶೇರ್.
That is correct.
ಹಂಗಾರೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಬಿಡ್ಲಾ? The trial court has held it 112.
I will go into the facts of the case. That is proposition of law, what you are proposition of law, what your lordship suggested is perfectly correct. Because
Study
section 8 will come into picture, all are become class 1
Yes.
equally
and
entitled for sale.
also look into exhibit D1. See
That
that
is factual aspect that I will go into the letter.
just look into exhibit D1. It has the nature of, it has the effect of ಏನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ father and son dividing the property exclusively and each not having a right over the other property.
There ends the existence of joint family.
Yes, joint family and co-personality.
That is termination of joint family.
Yes, if that is the effect, then they are entitled to 160.
Then co-partnership is not entitled, only succession opens.
Only succession opens. And they are entitled to 1/6.
Yes, that is correct. If the succession opens, co-partnership is does not arise at all in this case. As your lordship pointed out,
Yes.
only section 6, then section 8. That's all the picture. And schedule 1 the
ಆಯ್ತು ಅವ್ರು ಕೇಳೋದು ಜಾಸ್ತಿ ಕೇಳ್ಕೊಂಡಿದ್ದಾರೆ, but he fairly admitted he is entitled to only 1/6 in the course of the arguments.
Whoever the children of Mariappa, they will entitled for equal share.
Equal share. ನೀವು ಒಂದ್ಸಲ ನೋಡ್ಬಿಡಿ, we'll pass the judgment.
That is
Okay,
the
they
case,
also have
Malad,
scaled
I
down.
straight away consider Malad, that is no problem
Yes,
to argue.
exactly.
Yes. Please.
Friday,
ಆಗ್ಬೋದಾ?
ಆಯ್ತು ಮುಗಿತಲ್ಲ ಎಲ್ಲ.